Welcome to HRUnpacked, a podcast about HR workplace issues, where we analyse and then discuss the latest developments in HR and employment law that impact both employers and employees. Welcome, Kate.
Yeah, good morning. Good to see you, as always. Yep. Brilliant to be here again. And I'm kind of introducing someone I know just a little bit, really, a lot. We're really pleased to have Nicola Mullineux with us today as our VIP guest. And we're going to talk everything general election because it's coming upon us very quickly. And it's important that we get an understanding and dissect the manifestos, what could happen, how employment law has changed. So Nicola is the woman to have with us today. Nicola's the Associate Director of Content at Peninsula, where obviously I work as well. And we actually work really closely, so I think I've known you 15 years now.
I reckon, probably, yeah.
Yeah, I think we've grown up together, haven't we, from being, I think we were 10 at the time when we met. So yeah, really good to have you, and a really important subject for where we are in the lead up to the election. So Nicola, over to you if you want to do a bit more of an introduction on your experiences, what you do in your everyday.
Yeah, I think we are kind of giving away our ages here a little bit, but I've worked for the Peninsula Group for about 20 years now, mostly in a research analysis content role. And I manage a group of employment law technical writers and researchers and analysts, and it's our job really to be tracking all new employment laws, but also HR themes, you know, what's going on in everyday life, be it something like the Euro 2024 tournament and what impact that has on the workplace. We can basically get a workplace angle out of everything that's going on, but obviously new laws, any kind of new employer obligations, we have to track and then innovate to be able to find the best way to support employers and particularly small businesses to meet the new obligations.
Yeah, and we're actually just saying you're a graduate of Salford University.
I am.
You were here 20 years ago.
I haven't set foot in this building for 20 years, but it does bring back a lot of memories. Good memories, I have to say, yeah.
It's still the same building?
It is,
roughly.
yeah, but we always used to laugh because we used to call it Maxwell House, which is the coffee brand.
Yes.
Yeah, everyone calls it that, yeah. Okay, so you're very, very knowledgeable in employment law because obviously we've done some work together as well.
Yes, we have.
So how would you kind of describe the changes over the last couple of decades with employment law?
Well, I think, first thing to say is when I think about 20 years ago, I think we're talking about 1980, but we're not. We're talking about 2024.
It's true, yeah. I'm of the same ilk.
Yeah. So 20 years ago, we did have a Labour government. That was the last time that there was a Labour government in place. And I think there was an awful lot of laws introduced by that Labour government. Probably the Equality Act was their biggest achievement. Lots of laws that you will see will have a late 1990s year on them because obviously, as you would expect with Labour, they're going to bring a lot of rights in for the workforce. But I think, you know, it's an obvious thing to say, but we do have a lot more laws than we did 20 years ago. But having said that's obvious, it's probably not so obvious because of the referendum and the Leave vote and the opportunity then that the government had to remove a lot of the laws that we were required to bring in the UK, we were required to bring in for being a member state of the EU. And the opportunity for that came last year, but the government didn't take it. They did say there was thousands of laws they would look at repealing. And then probably realised the sheer task of that because there were so many laws to look at in such a short amount of time, and so then didn't take the opportunity to kind of strip back the law books as they had said they might do. So we still, despite the Leave result, we still have the very vast majority of the laws that we had before. But I think what there's been a real focus on over the last 20 years is family, work-life balance. So much focus on allowing employees or giving employees rights to be able in some way to try and balance balance their life basically with workplace commitments. So we've got the introduction of a lot of new leaves like shared parental leave, adoption leave became a day one right, carers leave even one of the most recent introductions in April this year. So much more focus on requiring employers to take that into consideration, to realise that people have lives outside of the workplace, outside of the 9 to 5, and how they can balance that.
I know we'll come on to it in a little while, but there's lots of family-focused pledges in the Lib Dems and the Labour manifestos as well, isn't it? So that theme continues.
Yeah. It's obviously an important one, though, isn't it? And I think the general kind of direction of things is that employees are individuals, and they're not robots, and they do have things to do outside of work, but you need to find that balance. You've still got a job to do, and businesses still need that work to be done, and you're paying someone for that work to be done. But in an emergency, or when something happens in life, there are many more rights now and protections for employees to be able to say, look, this has happened, I need some time off. And loads of employers go further than that. Loads of employers go further than what they need to, but there is now that much higher minimum floor of what they have to provide.
Yeah, okay. Is it worth just referencing April this year? Because this year, but forget the election. I don't think I've known, and I think we've been in HR for a similar amount of time. Yeah. I've not known a year of change like this. The changes that have come into play year to date have been immense. Is it worth just covering off some of those changes?
And I think we did think that was going to be the biggest thing that was happening this year, and then the election happens. So just in the space of a week, there were around about 10 employment law changes. There were the usual ones that you normally get, like national minimum wage increases, but it was different this year because it wasn't just a national minimum wage increase, it was an extension of that national living wage ban, so it was a greater impact on employers than it would be in a normal year. We had the introduction of carers leave, so now specific people with caring responsibilities get a right to take time off, unpaid time off, every year to fulfil those responsibilities. Paternity leave changes, which was a bit of a shock really, because paternity leave has stayed the same for years and years and years. Everybody knows you get 2 weeks, everybody knows you've got to give loads of notice, and it was a quite inflexible system, but now more flexibility has been brought into that, so that was a big one. That needed policy changes and practice changes and software changes to be able to for employers to get their head around the new laws. Holiday changes as well, so with 0 hours workers and irregular hours workers, part year workers, this all came from the Harper Trust case that was a massive shock a couple of years ago. So the law was changed so that people will accrue annual leave. 0 hours workers, irregular hours workers will accrue annual leave based on how much they work, which seems to bring some logic back into the system, some logic back into the judgment that did come across as quite...
I think it's fair to say Harper Trust threw us all off, didn't it? It seemed so peculiar in its findings.
I thought it was difficult for companies to manage it. That was the most difficult thing I found with that judgment.
Because nobody knew what to do, because it's the same with every judgment. A judgment doesn't change the law, it just creates that precedent, dependent on what level of court, but it means that if any future claims are brought, then you have to follow what the higher courts have said, but it still doesn't, because there isn't that solid change to the law books. It still leaves employers a bit unsure about what to do, especially at the lower levels of the court decisions, because you never know if it could be appealed and it could go further. So we did have to do a lot of hand-holding with our clients during that time, and option giving and telling them what, because it affects such a huge breadth of our client base. 0 hours contracts in irregular and part year. Basically everyone in education will work part of the year, although you might say different.
24/7, 365, obviously.
But for that area of the market, that was a huge change. So I think a lot of employers will have welcomed those changes in April, but some employees still have to wait for it because it's only from the start of your new holiday year after April. So a lot of our clients, a lot of employees in the country will have to wait till January next year, because that's when their new leave year starts.
Do
you think it was difficult to repeal some of the European legislation, because it's so embedded now, isn't it, into best practice, and just people accept it, and it's not just the case if you have to do it now, it's what they want to do as well.
And I think you'd really have to kind of get your pencil out and try and unravel the EU laws from the non-EU laws, because there's whole pieces of legislation that come from the EU, but then there's other bits that are kind of entwined in domestic laws as well. So I think that would have been, it's probably why the government didn't do it because it would have just been such a big job, for them.
Yeah.
That's not to say it shouldn't be done or it couldn't be done. It just would take some time. And I think, especially employers that have been around for a long time and know the lay of the land now, to then say, oh, that thing that you've been doing for 20 years, you don't need to do it now, would be quite tricky for them. But things change, time moves on. I think it's worth mentioning the Good Work Plan as well at that point, because that was a piece of law, that was a piece of research that started in 2017, I think it was, that was meant to bring laws up to date. It was meant to make laws applicable to the modern workplace. How much it did that, I don't know.
I think it got quite... It was lost as well in COVID, wasn't it?
Absolutely.
It was the 6th of April 2020. The date sticks in my mind. But it was pretty much coming into fruition at the same time, sadly. We all went into lockdown.
A month after the first lockdown, nobody cared that they had to change the holiday pay reference period.
No,
at that point.
Businesses were struggling to know how to operate, let alone change systems.
Yeah, which was a shame, because I think Matthew Taylor put an awful lot of work into that, and he did a lot of research, and he came up with so many recommendations, and that was the first date that the bigger changes were coming in. But it was changes to contracts or workers.
Just explain some of them changes, just in case it's lost on anyone that didn't engage with it in 2020.
Before that, in terms of contracts, only employees had to get a written statement of main terms, which is, we often call it the contract, but it's only part of the contract. It's the piece that by law you have to get in a single document. So it's got things like your name, employer's name, your pay, your annual leave, things like that. And the scope of it was broadened, so now workers are entitled to a statement of main terms, but you don't give them the same one, because it's really important that you keep your employees and your workers separately in the way that you treat them, because they have different rights. And if you start to treat workers like employees, then there is an argument then that they actually are employees. So workers are kind of your more 0 hours workers, the people that you might bring in when you've got a higher demand in hospitality. They're seen quite often, even in construction. If you've got a big job on, then you have your basic amount of employees you always have work for, and then you can bring these extra workers in, like bank workers in care, for example. So then they had a right to get a written statement of main terms, and then the information that had to go into that statement was expanded by an extra 5 things. And then there was things around holiday pay that I mentioned before. So the reference period for holiday pay was extended, just to be able to kind of better serve those people who work irregular hours. And it was really focused towards a gig economy. It's something that probably didn't exist 20 years ago, especially not with the exposure that it's got now. The Uber case obviously is the one that springs to mind with the gig economy, or the Deliveroo riders, or those kind of jobs where the fundamental basis of it is that you sit and wait for the work to come in, and then you do it. And that is a big change towards the direction of work that work is going in now. But will it still keep up with new ways of working? One thing we get asked about quite a bit now is influencers. What's the employment status of a social media influencer? And I don't know the answer, to be honest. I think with employment status, you just have to analyse the facts of that circumstance, and then use previous case law to try and direct yourself towards an answer. But influencers didn't exist 10 years ago. So in another 10 years, what newfangled ways of working?
Well, AI will produce new jobs.
Yeah,
exactly.
So, and I know it sounds ridiculous, but AI could produce work. And then we went to a conference, and they were saying AI would be the workers for the organisations, and what rights. I think it was at your one of the conferences that you had.
Right. Our legal director did a session on AI.
He did, Rob
McKellar,
And I remember him talking about AI and the work they did, and how it's regulated, and whether they would be workers or not, and how they would be protected. I mean, it's a far off thing, I think, but it has to be something you have to consider in the future about how it's regulated and managed, and what their framework is for working as well. Because it's more generative. We had it with Maria Kutar, who was a guest. So generative AI now is whereby they will be able to do things without being stimulated for a response, so they'll actually tell you something.
Without you asking
for it,
Right.
So, and that's what will happen. You've got brain box, which might head towards that, that in the future. But it is these new roles are coming up all the time with technology. History shows you that new jobs come up.
Yeah. And you have to embrace it. You can't be scared of it. I mean, your initial reaction might be to be scared of it, especially with technology.
It's defence, isn't it, as well? It's change, fear.
Yeah. But I think if you're a business owner, you're in a bit of a different position as to a team member, because you can use all that innovation and then use your HR department to get your staff on board and kind of understand that it all leads into the same productivity and success.
Do you think the laws have protected workers enough and also protected employers over the last couple of decades?
I think you will get different answers depending on who you ask, and I think going back to Harper Trust, you can get a decision like that where it's completely thrown all of your understandings up about how the law works to protect workers in a way that you never thought that it would. And I think that is a pertinent question to ask now, because with the election next week, who knows what's going to happen with employee rights and not whose side, but who's going to be more protected in the future. Just going back to that before, there's so many more rights in place now. So workers, employees have got so many more.
Didn't we say about 80?
There's about 80 pieces of law, and then a ton of rights contained within them. But I think that the distinction between employees and workers is going to continue to be important, because these workers are kind of considered to be an offshoot of self-employed people, and so self-employed people don't need any rights. So the concept goes, because they get to decide what they're doing. But workers are generally under the control of the employer, and so probably do need even more protection or even more rights than they've got now, because there's so many indications, so many aspects to their work that is the same as an employee. So why, there is a bit of flexibility there, but they still need, again, family rights. Workers don't have a lot of time off rights in relation to family and other life commitments. So I think that might be something, especially if Labour are successful and they do go ahead with all the pledges that they've suggested, workers will definitely get more rights.
Well, that brings us nicely on to 4th of July, general election, hundreds of pages of manifestos, which I know you've scrutinised and read to see what impacts that may have on employment law. So can you give us some headlines, a bit of a breakdown of what the main political parties are pledging? And to note, we're not political commentators. This is just dissecting the manifestos and what it says will impinge on employment law.
Well, I think if we start with Labour, purely because they put theirs out first, basically, I think it was they must have felt it really important to let the UK workforce know what their plans were, because they first put out their workplace reform manifesto back in January, and then rehashed it slightly in May. Probably they put it out just to see how it lay, what the unions thought of it, and then they made some changes in May. But they have pledged the most. There's over 60 HR pledges in there. There really isn't, I can't really see an area of law that they haven't touched or that they've said that they won't touch. But just to give a summary of the biggest ones, or kind of the most significant ones that will have the biggest impact, the one that everybody's talking about is giving employees day one rights for things like unfair dismissal, sick pay, parental leave. The sick pay and parental leave probably will have a bit of lesser impact, but currently you've got to wait 2 years, you've got to work with an employer for 2 years before you get unfair dismissal protection. And Labour said, no, we'll bring that back down to day one. But they have caveated it with saying, we still want businesses to be able to thrive. We still want businesses to have the best people working for them. And so you still will be able to make a decision around the suitability of that new person. And if they're not the right person, then we'll be able to exit them from the business. But I think there will be. It's conjecture at the moment, isn't it? They've put out their headline thing, this is what we're going to do, but then we can only.
It's got no detail, has it?
Yeah. But probationary periods seem to be really important for them. They say, you'll still be able to use probationary periods.
I always, sorry to interrupt, when I spoke to companies, I always explain the 2-year law, because it used to be 1 year, it's always gone up based on who's in government, and then say, well, we've got a 12-month probationary period.
Yeah.
So I always used to say, well, everyone's on a 2-year probation, technically, because within 2 years, apart from discrimination, you can terminate their employment as long as you follow a reasonable process. So it is I think that probationary period will be key within that day one right.
Because there's no legal construct to probationary period. You don't look at the Employment Rights Act and it says this is a probationary period and this is what you can do within that time. It's just a contractual thing that we certainly would.
It's a management tool,
advise,
really, isn't it?
Yeah, because it gives you that structured amount of time to say, look, after this month, 3 months, 6 months, whatever, we expect you to be at this point. You'll have had all your training, you'll have probably come across everything that you generally will come across in that job, and so we expect you to be able to have satisfactorily dealt with it. But
I was just
given that.
Sorry, go on. You finish.
You still,
go.
Even though you've passed your probationary period, up until your 2-year point, that is still considered to be what we would call a short service dismissal.
That term exactly is what I was going to say. The amount you talked earlier, Jonathan, about things being ingrained in people's brains about what they can and can't do within the law, and the amount of clients and businesses we deal with that go, this short service, so I need an exit plan, which however you view that is, you might have different opinions, but that is so ingrained in businesses thinking.
What's short service then? How do you classify that?
Anyone who doesn't have the ability to claim unfair dismissal, so it's 2 years.
2 years.
So
I
mean, it's an industry term. I don't even know if it's a company term that we use, but short will differ depending on whatever the law, however the law applies to that person who can't claim. So it used to be a year, and then now it's 2 years. But within that, probationary period doesn't really play a role within the short service. It just gives you that mechanism to have a structured conversation and use that to say, we don't think that you're suitable, or you've just not been able to meet our minimum requirements for this role, and then you've not passed your probation, or you can extend your probation. But I do think, and it is quite pertinent actually, that the probation period information now does have to go in your statement of main terms. That was a good work plan thing.
It was.
And so it's likely then that we will have to review the use of probationary periods, the structure around it, the wording around it, because if that is the thing that is going to allow, if Labour do get into power, that it's going to allow that short service concept still to happen, then we will need to make sure that employers can use it to their benefit. And that's not being pro-employer. Employers are obviously allowed to. You go through all your recruitment process, and you've got your best interviewers, your best questions. You might even have told the candidates what the interview questions are going to be before they come into the interview, because that's a thing that happens now. So they've best been able to prepare. They come across really well, they tick all the boxes, but then they come in on the first day and there's just something, whatever it might be, in actual lived life, it just doesn't work. And so employers should be able to make that decision that wasn't, they're not the best person for the job, and then we'll do it again to try and get the best person. So it's a fact of life.
Just picking up on that questions before interview, was it John Lewis's who they were in the press recently for that?
Yeah, it was one of the big company,
big retailers, wasn't it, that made a big thing about giving questions in advance to give everyone a fair playing field.
It's got a really quality stance on it though, because it's a real kind of inclusivity of neurodiversity. So I think it's known that people with certain neurodivergent conditions don't do so well under that traditional interview or assessment centre kind of setup.
Like an exam, isn't it, really?
Yeah.
So interviews are the least, research-wise, interviews are the least best predictor of the person doing the job.
Is that right?
Yes, or being effective in the job.
What's the best?
Assessment centres.
Oh, is that right?
Yeah. Somebody called Webb and his research team found it out decades ago, and it's still I believe it's still prevalent now, or still applicable, because interviews, it's a lottery. People are good at gift of the gab, they'll talk their way around it.
You Google what questions am I going to get asked, and then you just
But assessment centre, you're doing the job, and there's no better way of watching somebody actually doing a task all right, it's simulated maybe, but you're watching that person do the actual job and how they interact with other people as well.
Yeah, they're quite transactional interviews, aren't they?
Yeah.
So.
Yeah.
Okay, what other things have Labour said? Some of the key headlines.
0 hours contracts. Labour are not a fan of 0 hours contracts and never have been.
Yeah.
I think the Conservatives, they've latterly understood the fact that they can be used exploitatively, and I use that word because that's the word that's been used in the manifestos, and so have taken some steps over recent years to give 0 hours workers more protection. Labour have said that they will ban exploitative 0 hours contracts. Now that's not banning 0 hours contracts, it's banning the ones that have that one-sided flexibility. That's a term that was used in the manifesto as well. So ones which say, when I've got work to offer to you, I will offer it to you, and you have to do it. You can't change it. You've got no flexibility. I'm going to cancel it. I will give you your shifts a week in advance, and then I will cancel them, or I'll change it, or just something that takes away the earning ability of the worker and just that predictability. So what's going to be really important is the wording, the exact wording that's in every single. And I would say, if Labour do get in, one of the first things that you want to do is look at your 0 hours contracts and see just where the power lies there. Do you give that worker any flexibility? And we need to wait to see what exploitative means, or one-sided flexibility.
Yeah, it's interesting. I've got a friend who works in the theatre industry, and they said, and they run the 0 hours model really fairly. People love it. It works for both 0 hours staff member and the business. And they said without that in play, they just couldn't run the business.
And they still will be able to have those contracts. One of the questions I've been asked is, are we not going to be allowed 0 hours? Are we not going to be allowed workers at all?
Yeah.
And you will be able to, but you're going to have to look at how you're doing it. And it may, the balance of power may tip, and you may have to change what you're doing, but you'll still be able to do it. You'll still be able to have the not full employee.
0 hours contracts. The CIPD did some research on it, and I think a high percentage who were on them wanted 0. A high percentage wanted to work 0 hours because it's beneficial. There were single parents,
loads
students,
of society,
people who want to work on 0 hours, but it's the exploitative nature of companies. Sports Directs come to mind, not just naming them, but I think they prevented people who'd signed 0 hours contracts from working anywhere else.
Yeah.
There was that, I can't remember what you call it, where you're not allowed to work somewhere else. Yeah, exclusivity clause in it. So that's always a problem. You bring out these really good things where people can work flexibly and it suits their lifestyle. Then you get certain companies who do exploit the workers, and then that spoils it for everybody else. Because I think it is something which a lot of workers want.
Or older people, for example, who kind of want to semi-retire but still want to keep their hand in, or people with some really rare skills that aren't needed all the time. So I think they are a good thing as long as there's some rules.
The last thing about Labour then, don't want to bring it in within about 100 days or something. You mentioned it today,
this 100 days has definitely been used. So they've said that the specific wording is they will introduce legislation to Parliament within 100 days, which it doesn't mean that laws will be brought in within 100 days. So what's that, like 3.5 months?
It's October.
Just because of the legislative process. So they'll have to do a consultation. I think Parliament opens again on the 17th of July, I think. Then they've got to start consultation. Consultations normally last about 12 weeks. They can do them shorter, but I think if they're, depending on how much they're going to throw into it, they probably will have to do the whole 12-week thing.
Yeah. It'll shut down for summer. It'll shut down for summer though, won't it, Parliament as well? It has a closure over the summer period as well.
And then after the consultation, they've got to analyse the responses and then create this law. So they've got a lot to do in that 100 days. Some of the things that they've said, they've acknowledged that some of the things that they've pledged will take longer. So they want to create a single status of worker, which is merging together the employees and the workers that we spoke about just before. They'll do a full consultation on that and then see how that will go. That's going to take longer. And the review of parental leave as well. They want to knock parental leave down to day one, and they've said that will be pushed back as well. But they've got 5 years, the maximum 5 years Parliament until they have to do another general election. And with the sheer amount of stuff that they've said that they'll bring in, I think they will need that 5 years.
Yeah. And what about Conservatives then?
There's a stark difference in the amount of pledges from the Conservatives and Labour when you compare them, but some of them are quite substantial. So one of the things, and they've already kind of put this out there, they'd announced proposals on it before the election was called, is the reform to the fit note procedure.
Yeah. Was that the headline, get a grip, get a job, which caught the media attention?
Yeah, I think there's a few different facets to it, but they said that GPs, they've done some research, GPs, I think they said spend 30% of their time on non-clinical work, which includes writing fit notes. We all know that the NHS isn't in the best position that it could be, and so they're looking at ways to take the pressure off GPs. So they said, we want to stop GPs having to write fit notes. You can get fit notes from other professionals now. That was a legal change, I think, in the last 2 years. But most people still go to the GP. So they said, right, well, we're going to introduce this triage system where if you want a fit note, then we'll triage you to make, and then point you down the most appropriate pathway, either a fit note or you'll go and see a work and health specialist or a different programme. This is all the detail that we've got. So I think it's probably going to shake up people more than employers, because I think people may have got used to quite easily going to the GP and getting a fit note. And so if there is going to be a potential blocker there, that might be a bit of a shock to the system. But we need, if there is the opportunity for them to do it, we need to see how that is going to play out. But it would mean a change to sickness absence policy, absence procedures. In the absence of a fit note, if it's decided that the person isn't going to be pushed down that pathway, then what does that mean for the employer? So again, lots of unknowns.
Yeah. But when I used to, this is anecdotal, but when I worked in HR, the sick notes, as we called then, they were looked on sceptically, because I think GPs signed them and not necessarily did a thorough examination in comparison to an occupational health advisor, for example. So, it probably does need to be looked at in terms of the time that it takes to fill them out, and the robustness of them as well.
Exactly, and what you get written on there. I know fit notes are styled now that you can make suggestions of this person may be fit if this happens, like a phased return or something. But I think the general feeling out there is that still GPs don't put enough.
There's no consistency. There's no consistency about the details on it.
Yeah. And that is at Peninsula still always in our top 3 nature of advice codes. Week in, week out, sickness, disciplinary, top, up there. So it's a massive issue for businesses and employees alike, of course. Yeah.
But there definitely seems to be much more of a direction towards to try and not fix, but try and make that system a bit better.
It's the depth of it, isn't it? I think.
And especially with mental health, because that's coming up a lot more now. You get a lot more fit notes that have a mental health condition on there, and employers still just go, oh, what am I going to do with that? Because I can work with a broken leg, I can work with a bad back, I know what to do there. I know how to take that forward, but when it's mental health, I don't really know.
And they are designed to help the worker. That's what they are there for, is to look at, they are genuinely sick, and these are what support mechanisms are required for the company then to work with that person, so they should be a supportive measure.
So Nicola, what about Lib Dems? Because from what I've seen, there's a lot of family-friendly driven pledges from that party.
So they've been quite detailed in what they will do. Like, it's quite strange, you don't get an awful lot of detail in some manifestos, but then they've been quite clear on the increase to family related pay. So paternity, parental leave they want to bring back down to day 1, like with Labour, but they will double paternity leave. So paternity leave is 2 weeks, you'll get 4 weeks. They'll make some changes to the shared parental leave system so that I do wonder though whether, and this is personal opinion, whether shared parental leave is something to spend your time on, because not a lot of people take it.
I see very little take up of it.
Yeah, I think the general statistic is that 2% of the people that are eligible to take it do actually take it. Having said that though, I know some people that have taken it, but then there will be loads of people who don't do it.
Do you see a lot of traffic on maternity versus paternity, a year versus 2 weeks? i.e. that disproportionate amount of entitlement.
Yeah, I mean, that's exactly what shared parental leave was put in place for. And you do often see commentary that paternity leave is just not long enough. I think I saw something last week that said employees are taking annual leave to top up their paternity leave because 2 weeks just isn't enough. And I think the details with paternity leave are like you never quite know when you're going to take it because you can't take it before the birth, so it's always a bit
I just remember it's a vivid memory 2 weeks after having my daughter and waving my husband off thinking what the hell am I supposed to do now. It's very short.
Maternity leave is really about, it's a health and safety measure, especially like the earlier part, and it's for to the concept is, whether people still agree with it or not, to nurture that bond between mother and child. But then the other side of it is, well, what about father or mother's partner and child? You know, they deserve the bond opportunity as well.
That the problem with shared parental leave is the finances, because you know, generally the father does earn more than the mother. So financially they can't take it off. A lot of Scandinavian countries are now addressing that by, I don't know how they actually do it logistically, but there's no financial detriment to taking shared parental leave.
Right.
So if the father does take shared parental leave, they're not affected financially. But they've obviously got a different state system to cope with that. But that's the biggest problem with shared parental leave.
Which you get in terms of the cost of living, you know, it's just difficult, isn't it?
I think the UK is kind of ridden on the glory of, well, we give one of the longest periods of maternity leave in the EU, but the pay just doesn't, the minimum pay level just doesn't back up the ability to take that, because the last 13 weeks is unpaid completely. Another interesting point then for the Lib Dems is that they want to add to the list of protected characteristics under the Equality Act, which nobody has done for a long time. We've had the 9 protected characteristics. There's been talk about including other ones like caste or menopause.
Menopause was a big one.
And the decision has always been no. So they want to add caring responsibilities and care experience as a protected characteristic.
I thought the latter one there is really interesting because it's very specific, isn't it?
And it's not something that anyone ever really has considered from an HR point of view before, never really has been required to because of the law.
And I am right, that's someone that's been in care.
And their opportunities then to get a job. And keep a job. And I do remember reading something in the last year about that, how difficult it is for people who've been in care as a child to then move into kind of valuable employment. So that would mean then that people cannot be, you'd have to treat somebody with a childhood in care with the same kind of thought and consideration as you do with not treating somebody detrimentally based on their race or their age or their disability. It would have that level of strength behind it. But caring responsibilities is an interesting one. Again, carers have just been given the right to carers leave. It's a week off pay, so it's not an awful amount, a lot of time. But again, they would be given this equality protection. So quality policies would have to be completely rewritten, and you'd really have to think about your recruitment and your inclusivity and everything, even equity now. That's making its way into a lot of equality policies. National minimum wage, they want to put give a higher national minimum wage to care workers, so whatever the national minimum wage is plus £2 to care workers, and 0 hours workers to just kind of counteract the unpredictability of the work.
And other parties? I see, obviously reform been in the news a lot.
Because they at last looks they were polling higher than the Liberal Democrats. They were behind the Tories but above the Liberal Democrats, but that's changing all the time, completely fluctuating all the time, depending on who you look at and where you look and where you read. Again, a small amount of pledges, but some quite wide-reaching ones, but no detail. So the biggest thing they said they'll do is they'll scrap laws that are holding businesses back, including employment laws. That's the statement. No more detail. So you are just left thinking, what could that be? Your mind goes to anything that prevents a dismissal. So fire and rehire. You know, the the direction is definitely going towards removing fire and rehire. And that's one of Labour's pledges, but would reform push it the other way.
Yeah.
And they also said they will replace the Equality Act, but not remove it, replace it, but we just don't know.
Don't know with what.
Would be, yeah. So that really is the fundamental fairness, equality legislation that currently exists, and so it would be interesting to see. But I think they would really be quite wide.
Yeah.
Reaching changes.
Okay, I mean, a lot to think about.
Do you know what the trend is in terms of employees? What protection they want?
What do they want?
Yeah.
I think most people would say that the general appetite right now is for home working, flexible working, more rights to do with flexible working. Labour have pledged to change flexible working, Liberal Democrats have as well. What they're not doing is saying everyone will just have the right to do flexible working or work from home. They're just changing the terminology around the right of an employer to say no. So Labour is saying flexible working would be a day one right for everyone unless it's not reasonably feasible. That's the wording that they use. I mean, it's quite a broad statement to say that every employee wants to work from home. Some people don't. I don't. I'm an advocate for office working, but because it works for me. But I understand that other people will say something different.
If you've been allowed to work from home for a certain amount of time, 3 years, 4 years since the pandemic, how can companies force people to come back into the office now when they have been allowed to work from home?
Yeah.
Do you think because some of the big companies in the UK have said we're going to get staff to come back into work now?
Yeah.
And you're right, some staff are fine with that. They do want that, especially the younger generation. But how difficult might it be for companies to get people to come back into the office legally?
I think there's so many kind of different variables to that in that answer. I think it is difficult. I think you look at the newspapers every day and you see that it is very difficult, and employees certainly don't want to do it. But it all depends on what were the contractual provisions in the first place, how was it expressed, and is it just a way now that, playing devil's advocate, that there is a new norm of home working productivity that is good enough but perhaps wasn't as good as it was when people worked in the office. I try to stay on the fence in things like this, but I know my brain is saying to me office working is best for me. So if I was made to work from home, I didn't like lockdown from that point of view at all, the working from home. Somebody else, you might bring in somebody else who really wants to work from home and they'll say something different. But I think it is very difficult, but it's all about the communication and how you do it and what contractual provisions you've got to stand on in the first place. But it is worth mentioning that case, and the name escapes me right now, but within the last 6 months where an employee wanted to stay working from home, and the employer, she said, I've got Teams, I've got everything, there's not enough space in the office, I've been working at home for so long, everything I can do over Teams. And she was a manager, and the employee said, yeah, you can do it, but you just can't do it to the level that you used to be able to do it, or to the level that we'd like you to do it at. And she made a claim to Employment Tribunal, and the employer won. Now that's just an Employment Tribunal level, so it's not binding, but it does put something into the minds of employers that employees can't just rely on the fact that technology is available to be able to enable them to do their jobs. What other things do they need to do, especially as more senior employees?
I think she was, what stood out to me, she was a leader, weren't she?
She
as
was
well,
a manager,
managing a team whose team members were in the office.
Yeah.
So it adds quite specific facts to the
everything's
case.
completely fact-based. But I just remember when I was coming into the office during COVID times, I was the only one on the train. It was lovely. I really, really liked it. And slowly, more people.
Yeah.
And nobody would sit next to. It was always like have somebody in a seat, and then they'd leave a gap there. And now it's just you're like up against.
It is interesting though. Our demand to our advice line is fluid, dependent on regular home working days. So your Mondays and your Fridays we get a lot lesser demand than we would midweek when you see the traffic on the roads and everyone going in.
Wednesday's
so it does
the busiest
feel
day,
like you get a peak of productivity midweek. Interesting.
But I think not every employer is against home working.
Very specific, isn't it?
Yeah. As much as employees have their own individual personal view about what works for them, a business owner will have that as well, and then they'll work to whatever principles they have or experience they have of how it worked during lockdown. But lockdown was just a time like no other, wasn't it? It wasn't normal. There was nothing normal about it. And so I think to use that as a comparison period perhaps isn't the strongest argument. But you could debate for hours and hours about home working.
Yeah, I think most companies will rely on the productivity angle of it. If they are productive, then it's beneficial for them. That's what they always go back to that.
Yeah.
A lot of businesses, don't have property costs to pay for. It's so industry, business, commercially dependent.
But then also individual dependent as well, because what if somebody just hasn't got the setup to? If you make everybody work from home and they haven't got the setup because of whatever reason, or just something, people felt isolated and mental health wasn't great during COVID for loads of reasons, but somebody working from home not having that ability just to turn to the colleague and just have a chat, or
absolutely,
not necessarily a social chat, a work chat, or just remind what I'm supposed to do with this. It's just it has a big impact.
Well, it looks like whoever gets in, you're going to be busy analysing and researching what the laws are going to be. And advising the clients. So thank you for your time today. It's been great.
Oh, you're welcome.
Yeah, thanks, Nicola. Obviously, we speak every day, but it's a pleasure to have you. You're so knowledgeable, and you do such a brilliant job for myself, our team, and Peninsula and our clients. So we really appreciate your time. Thank you.
Thanks, Nicola. You can watch HR Unpacked on YouTube or listen to the podcast on Apple Podcasts, Spotify, and other platforms. Just search for HR Unpacked.